Okay, concentrate. Concentrate. Okay. So let us start the next chapter, interpretation of statutes. Important from exam point of view, yes. You can expect one direct question for sure. Most of the cases, it will be a direct question, but here and there, somewhere they twist and ask. It can be an indirect question. I tell you, a couple of times they have asked an indirect question. But if you guys understand the concept, you'll be more or less able to write it. Yeah. Chapter weightage can be anywhere between 5 to 8 marks. Yes. So, interpretation of statutes. Clear? Yes. Okay. Now, what do you mean by interpretation of statutes? Why do we need this? Which act? Interpretation of Statutes Act 2000? No. 2008, 2005? No. It is not an act. It is an act. No. People remember iOS is not an act. It is just an aid. It is a help. What is an interpretation of statutes? What do you mean with the word interpretation? People, what do you mean by interpretation? Understand? Now, whenever I'm not able to, now, for example, when I go to, I'll tell you one example. Let us say, okay, I'll tell you, guys, tomorrow let's have a class at 4 o'clock and I leave. Now, what time will you guys come? 4. Now, I did not mention PM or AM. Agreed? Now, how did you guys think that it is 4 p.m.? Now, this is called interpretation. What in all your mind have thought, hey, 4 a.m., no one will have a class. It's way too early. And for 4 p.m. only we sleep. So, the sir definitely wouldn't have called at 4 a.m. Now, people, your mind worked to just analyze what that 4 p.m. or 4 a.m. is. Exactly is what the concept called as interpretation of statute. Now, when you're reading a law, there are so many places where the lawmaker wouldn't have said something way too clearly. It might be vague. It might be ambiguous. Now, some words they would have used just like that. Now, I cannot understand, I cannot interpret the law by using this particular word. Now, in a court, what happens? You would have done a transaction. When you go to the court, now there will be an ambiguity. Now, for example, there is a big ambiguity in Companies Act only. Even in LLP, it's there. What is that? When number of people fall less than the minimum requirement, Section 3A of Companies Act, Section 6 of LLP Act, when number of people, that is shareholders or directors, I mean shareholders or the partners, if they go minimum less than the minimum requirement, what will happen? You saw that it can lead to winding up unlimited liability. All of that you remember, huh? Yes, sir. Now tell me, when does the unlimited liability actually start? I hope you guys know that section. Yes, this is the law. Hello? Okay. Section 6 of the LLP Act 2008 mandates a minimum of 2 partners for LLP and holds a sole partner personally liable for obligation if the LLP continues business for more than 6 months with only 1 partner. This personal liability obligation incurred during the period that the business is run by a single partner after initial we want yes, sir. They just now they increased it. I think Venkatesh did it. How much you did, Venkatesh? Agila. Steve knows it. So I did for 30. 30. Okay, do 40. Steve is doing it. See, 29. No, keep it 26. It's off. Hey, that I think it will pour. Water will come simply. If any issue happens. Okay, now see I'll show you now. See here. If at any time the number of partners of LLP is reduced below 2 and LLP carries on business for more than 6 months while the number is so reduced, the person who is the only partner of LLP during the time that it so carries on business after those 6 months and has the knowledge of that fact that it is carrying on the business with him alone shall be personally liable for the obligations of LLP incurred during that period. Now, what do you mean by during that period? Now, for example, let us imagine if I have to ask you a question. Let us imagine this is unclear. I can only tell you. I will give one interpretation. Someone else can give one more interpretation. Yeah. Now, what do you mean by this? On first Jan 2026, the total number of partners came below the minimum requirement. Now only one partner is there. Now the law gives me 6 months time. So 30th June 2026. There was a contract that we entered on 1st February 2026. The contract continued until 30th June 2026. We did not even add one more partner. Now, on say for example 10th July 2026, we entered one more contract. This is contract 1, this is contract 2. Now still there is only one partner. There is no new partner added. Now sir, on 1st August 2026, the partner is coming and asking your opinion for which all contracts I will be personally liable. Is it only contract 2 or is it is contract 1 and 2? What do you guys think? It is not yet fulfilled. It is still going on. So it's both. Now, if you want, you guys understood the question, no? And now I'll show you the what is that? Your section only. Now try to interpret. I hope you guys are able to see it. Now see, during that period, that is what they say. After 6 months, you are liable. But for what contracts? Read it. What they have written. Of the fact that it is carrying on business with him alone, shall be liable personally for the obligations of LLP incurred during that period. Now, what is that period? After 6 months, or should I consider during that period as however long you have acted with only one partner? Should I consider it like that, or should I consider during that period as after 6 months, whatever contract you have entered? What should I consider it as? Now, people, I'm not going to give the answer here. All I wanted to say is now statute has a deficiency. There's a confusion in the act. Now imagine on this scenario, if you go to a court, there is an actual LP. Let us take this only. There is one partner. So someone has filed a case on this partner saying that you are personally liable for both the contracts. This partner is saying, no, I'm liable only for one contract. The matter has gone to the court. Now in the court, the judge has to decide, no, where it is written, what do you mean by during that period? Now what to do? Now what do I do? Exactly why this particular chapter is there. That's the meaning of interpretation of statute. Like this, I can show you some 100 places in Companies Act. At least 100. Meaning, it is not clearly written. Now, on such dispute, if you go to the court, can judge blame the lawmaker? Hey, you could have written it carefully, Noda. What do you mean by that period? Can I blame it? No. Then what should a judge do? Remember, what a judge is doing is called as people. He's trying to understand. He's trying to interpret. Okay, what this during that period could have been. What does the lawmaker, his intention could have been? I will try to understand, not just read the word. If at all a judge is doing it, people, we call that mechanism as interpretation of statute means what? A law. Understood? Pakka. Hello? Sir, in today's date, is it required? Macha pakka required. Sir, why sir required? One day what happened? One day. One day. Sir, what is the answer? Ayo, that is a controversy. Okay, what did we see in section 3A? From when? Tell me, as per section 3A, contract only two liable, contract 1 and 2 liable. As per section 3A, what interpretation you guys have seen? All two. That is both the contracts. Yes, sir. ಯಾರೋ ನೀವುಗಳು ಒಂದು ಕ್ಲಾರಿಟಿ ಏನಿಲ್ಲ. That is what you read. What does the dissolution of LLP say? Tribunal may dissolve LLP. Just because you cross 6 months directly, will not pass off a dissolution order. It is one of the grounds for dissolution. Clear? Hello? Is clear? People, how do I read it? Now, interpretation. People, if you ask me, if I have researched about any one particular thing, so much is this section only. So I'll tell you, any teacher in this world, if they have given an interpretation, I would say it is their interpretation. I would still say it is not a right interpretation. Why? Till date, they have not yet asked this question in the exam. Neither has it been interpreted by anyone. So it is only like people like me, you, another teacher, another author is what they are interpreting. There is no any precedent or a judicial decision made on this particular section. Yes. So now how do I interpret it? I will take it as the first to 6 months. The law has given me a right. I'm still within my time period. So in this phase, the partner has not done any non-compliance because this is a phase, law has given you time. So in this case, in the phase of first month to 6th month, your separate legal entity concept will still apply. Separate legal entity concept means for LLP's liability, LLP will be liable. Now, after 6 months, now what you have done? You have done a breach of contract. Now, within 6 months, you should have appointed one partner. You have not done. Beyond 6 months, the separate legal entity concept comes to an end. So, people, whatever contracts I enter after the first July 26, that is nothing but after 6 months, whatever I enter, for this people, I can be made personally liable. Why? During that period means what? The 6 months is given to me by law only. There I'm lawful in what I'm doing. In that time, the liability will be on the LLP because separate legal entity concept is there. Now to emphasize on what I'm saying, today's task, go and see any YouTube channel, any author, any teacher. This point would be in 2x speed. No one would have explained it. Why? Because the law is imperfect. Now imagine I'm saying this. What if your institute gives a different answer in the next attempt? I have to bow down my head. Because even today it is an interpretation. I can give you a second interpretation also here only. Now, don't judge me for being wrong. And don't judge me for being right. Because every teacher knows that there's a two interpretation here. Hello? That's why our institute also has never asked this question. Understood? Chanchal! That's why Chanchal should be there. The effective question. Understood? Yeah. But here and there, now you can ask, sir, on what basis you came to a conclusion? Some articles I've studied, some articles. I believe in major blogs, someone writing it. I follow certain people, certain law journals. In those places, they have taken an interpretation of what I have said. I've seen there are two cases, but that also they have just taken the 6 months part. That's all, not for the sake of contracts. So there is no case. I can be 100% sure on it. 100% R&D done. Yes, sir. Hmm. That's what I'm saying. No case. There is one case of something called Mahanand or something comes where they have touched this section, not even under Companies Act 2013, under Companies Act 1956, section 45. Same section was there. That time also it was written like this only. That time also they have not spoken about the contract part. They just given the reference of 6 months part. That's all. When the liability starts and all is not the case. Now, see, randomly I did not interpret anything. And this is what Gemini thinks. Yes. Nowadays, even Gemini also can be considered as one more person. Yeah. Hey, without a substantiate records and what is that? Journals or any blogs written, it cannot interpret on its own. Somewhere this is there. Now read what does it say? It mandates minimum. Okay. Liable for obligation if the LLP continues business for more than 6 months with only one partner. This personal liability applies to obligations incurred during the period that the business is run by a signal partner after the incurred means started. I can give 4 blogs which has same interpretation. That's what I'm saying. But am I right? I may be wrong. Exactly. Welcome to the world of iOS. It is different for you. It is different for me. We have to go with what a judge says. Unless something like that is prescribed. Sir, if not, I'll tell you one more thing. You want me to put one more insect? So it's Saka. ಬೇಡ ಏನ್ ಗೊತ್ತಾ ಇನ್ಸೆಕ್ಟ್ ನಿಮಗ್ ಬಿಡ್ತಿಲ್ಲ ನನಗ್ ಬಿಟ್ಕೋತಾ OPC resident or otherwise. What do you mean by resident or otherwise? Whether resident also okay, non-resident also okay. Then what is 120 days condition? iOS. I can show. Yeah, take it. Huh? If president, you should stay 120 days. Okay. What if I've stayed 115 days? Can I start a OPC? Then what is the use of 120? But if you guys want, on that also, I have made one 20-minute video on YouTube. It is there. Search OPC resident or otherwise. Full conceptually I've explained. There is actually an interpretation. Now I can't explain that, but there is an interpretation. It is actually a huge one. So I've taken the Nirmala Sitharaman's budget speech. And what is the intent for her to say resident or otherwise? Based on that, I have tried to interpret again a word where no one would be focal. That would have just been a condition in 2x. Trust me. Yes, yes. Interpretation. Bada. Huh? Huh? Correct. So it is something to do with NRIs. If you are an NRI, that particular condition will apply. Hey, Saak, bro. People see this. Again, Companies Act, there is something called Nidhi companies. A Nidhi shall provide loans only to its members. See from there. One, the loans given by a Nidhi to a member shall be subject to following limits, namely 2 lakh rupees where the total amount of deposits of such Nidhi from its members is less than 2 crore. Meaning what? If the total deposits Nidhi has accepted, if it is less than 2 crore, one person can get a loan up to 2 lakhs. So total deposits, if Nidhi has is less than 2 crore, one individual can get a loan of 2 lakhs. Okay, second one. 7,50,000 rupees where the total amount of deposits of Nidhi from its members is more than 2 crore but less than 20 crore. Is there any problem here? No. Now I'll show you the problem. What does condition A say? Members is less than, what is the total amount? Less than 2 crore. What does the condition B say? More than 2 crore. Where does 2 crore come? Macha, less than, you don't round it off. Less than 2 crore is 1.9999. More than 2 crore is 2.001. Where does 2 crore come? That's why we need to write 2 crore or more. Yes. Like this is only Companies Act. How many acts you think are there? So are there problems in all those acts? I'll tell you one scenario. One scenario, Macha. Hey, Macha. One day what happened? One day there's a company. Huh? There's a company A. There's a company B. There's a company C. There's a company D. Yes. Company B is a holding company of company C. Company C is a holding company of company D. So company D is a subsidiary of company B, deemed subsidiary company. One day what happened? One company wanted to start one business in India. Yeah. So if a company wants to start a business in India, there are always two routes. First one, you only start everything from scratch and build it from scratch. The second one is people, there is already one person existing, acquire him, easiest way. So there is a company A who wanted to come to India. So they chose the second route. Instead of me starting everything from scratch, why don't I just acquire someone from India? So what did company A do? Company A came and acquired. There is a company D. What is this company D? Company D is in India. Where is company C? Company C is in a place called as Cayman Islands, which is a tax-free country. Now, in this case, what happened? Company A went and met. Company A went and met. Company C, Allah, they went and met company H. Oh, sorry, company B. Now, company A went and met company B and they said, Macha, you have 100% of shares in company C. No. Can you sell those shares to me? Company B gave a number. Company A said, I'm okay. And hence, people, the 100% of shareholding of company C was acquired by company A. And this became a holding company. Now, this became a subsidiary company. Now, where is all this story happening? All this story is happening in the Cayman Islands. Hello? Understanding? This company B was holding company C. Holding. It's all Cayman Islands only. Agreed? Where is company D? India. Now, ultimately, what happened, people? The top complete holding company on the top, the ownership changed. Because of that, in India, all of a sudden, This company D is there, no? Rebranding of company D started happening. Everywhere they had put their name as D. All of a sudden they're changing their name from D to A. Everywhere in India. We were seeing it as D, it is becoming A. Everyone just saw it, left it, but one person felt uncomfortable. They said, hey, how can this happen without me knowing the? And this company got a notice from our income tax authorities. They sent a notice to this company D and company A saying that you have acquired one company in India. It is a capital account transaction. You need to pay tax on it. It's a capital gain. You need to pay tax. This entire transaction is subjected to tax. And hence people, the total value was a crazy amount. The total deal value, it was, some billions of dollars. And our authorities sent a notice of tax for them to pay 11,000 crores. Who sent it? IT department sent it. IT department. Only tax. We sent a tax notice saying that you have to pay us around 11,000 crores. Yes, sir. Now, people, before knowing what happened and all, first let us try to understand who these companies are. In these two companies are very important for us. This company A is none other than Vodafone. This company D is none other than a company called as Hutch. I don't know if you guys know, if you are from that generation, there is one dog which became popular because of this company. And that dog is called as Pug dog only. They used to call it as Hutch dog. And the very popular tagline of Hutch was, wherever you go, our network follows. Yes, sir. You'll not believe Pug was nothing without Hutch. Huh? There is I'll show you. There is a whole chain. One is called CGP Investments, one is called as Hutchison Investments, one is called Hutch. Yes, sir. Forget those names. CGP Investments, it's called. For us, the more important part is the one in India, Vodafone and Hutch. So Vodafone started rebranding Hutch as Vodafone. That's how Vodafone came into India. They acquired Hutch. Now the question is, did they even pay 1 rupee in India? Did they buy one asset in India? Nothing was done. Now what happened? Vodafone said the same thing to the IT authorities. Hey, what does your law say? If at all any transaction happens in India, it can be a transfer of asset, acquisition of property. I need to pay tax. Macha, I did not touch 1 rupee in India. Why should I pay tax? People and our Vodafone did not pay tax. IT department did not live. They went to Bombay High Court. Bombay High Court said, hey, whatever IT department saying is true. If a transaction happens in India or outside India, there is a transfer of undertaking or a name happening in India, right? Who cares where it is happening? Then how did Hutch became Vodafone? There's a transfer of undertakings that is happening, and hence you need to pay tax. Who said? Bombay High Court. Interpretation. Now, Vodafone people, as per the Bombay High Court's order, deposited the entire IT amount of 11,000 crores. They further went for an appeal with Supreme Court. Supreme Court. Now, Vodafone is saying, sir, what are they telling you? Have you read your law? I said, why? What happened to the law? Sir, please read it once. So, now we are reading the law. What does our law say? Our law says, section 9 says, okay, read here. What does section 9 of IT Act say? Now, Vodafone is showing this law in Supreme Court. It is saying, sir, all income arising directly or indirectly through or from any business connection in India or from or through the shall be deemed to accrue or arise in India. Now, Supreme Court, in front of Supreme Court, Vodafone, just like I showed, they also circled in every place. Sir, you know what was transferred? You're telling capital asset was transferred. No. Do you know what was transferred? What was transferred was shares from that company to me. What we acquired was shares, and that was not in India. That was from somewhere outside India, and that place is called as Cayman Islands. Your law is so clearly writing in India, in India, in India. This is not in India. And who said? Vodafone. Where did they say? Supreme Court. And Macha, welcome to iOS. Supreme Court said what Vodafone said is right. Supreme Court reversed the decision of Bombay High Court. They said the way the law is written, it is clear the transaction to be taxed, it should arise in India. In this case, nothing happened in India. Now, people, that day's president, Pranab Mukherjee, said, what are we doing? And hence, they passed an amendment saying our intention in the making of law, our intention was not this, our intention is this. Saying what? Whatever we meant in India, it actually means even if a transaction happens outside India, if an effect of it is there in India that can be taxed, is what the intention was. Hello? Supreme Court said, Macha, you cannot make a retrospective amendment. And literally one of the, again now I have to connect the audio video and all, there is one interview where one of the journalists has asked this particular issue with Pranab Mukherjee directly. Are you aware of the fact what others are commenting about India? I do a transaction today. After 20 years, India can bring in a change and say it is an amendment and not prospective, not from today. It is retrospective. Meaning, I'll say minimum attendance. If not, I'll cancel your recorded classes. I'll say minimum attendance is 90%. Are you guys okay? Now, I'll say not from today. It is from the day you guys joined. Correct? No. Correct? No. Now, people, I can make a prospective amendment, not a retrospective amendment. Because everyone would have done a transaction as per that. Hello? No, sir. Supreme Court passed a judgment. What did they pass? Supreme Court said, Dear Vodafone, you are entitled for recovery of the entire 11,000 crores you have submitted. And Supreme Court passed an order to repay the entire loan to Vodafone. IT department had to repay 11,000 crore with the interest of 57 crores. That is capital asset. You have created a capital asset in India. But IT, should I tax it? How will I refer FEMA for that? Asset is created. Even I am not denying, neither Vodafone is denying. Your asset is created. But I did not buy anything here, right? Yes. Hello. Understood? iOS. So iOS is not something like a goalie. But for us, yes, overall, the industry says a dry chapter and all correct. True. But the importance of iOS is not the way you think or the way people depict that it's a dry, it's a theory and all. It's not like that. iOS is very, very important in the court of law. Very, very important. No, right. Uh, Airtel and Jio. Huh. That is CCA, Competition Commission of India. Yes, there also it happened. Airtel questioned Jio that whatever you guys are doing is anti-competitive. And they filed a case on Jio because they gave free no. But Jio won the case saying that not majority. One is yes, we are not having dominance because the market is distributed. Second thing they said was it was a usual marketing strategy any new person would do in the initial phase. Everyone would have done. Buy one, get one free, or you refer, I'll get 100 rupees. Everyone would have done that. So on that grounds, Competition Commission of India said Jio has not done anything non-competitive. Yes, sir. Yes, there are crazy cases. You know, there has been one case filed against Google on they are killing competition. They are creating monopoly in India. You know, on Google they have filed, and you know they won also. Google paid a penalty of 1,700 crores. Sir, why sir anti-competitive? CCA only filed. Competition Commission of India. But do you guys agree? Google is killing competition in India. You guys agree? Yes, sir. You using Google, you use Mozilla Firefox, who's stopping you? Then why is it called as killing of competition? I'll tell you why. You open your mobiles, try to delete YouTube, Google Chrome, whatever are the other apps, try to delete it. Macha, just for your information, da, you guys don't even know there is a second app like YouTube that exists. Tell me one app. Okay. Yes, people, you know Twitch. Exactly, I'm saying. You tell me, you're saying what is the market of this Twitch? How many of you guys are using it? Don't you think Google killed it? Macha, Google slammed it into the ground. Yes, you know why? There is an agreement that Google enters with Android. You cannot give an option to delete it. These are called as pre-installed apps. You are not installing them. That means it is forced on you. You thought you are using it. Ah, illa, they are making you use it. On that ground, it was a case of CCI. See, CCI on its own, Competition Commission of India. Huh? Nothing changed. Exactly. But now it's not that Google cannot have an agreement that others cannot be restricted from being installed in the phone. Now imagine you guys said Twitch. Till today, there was an agreement that Android should not allow Twitch to be installed. Today, that cannot happen. Now, if Android still does it, it's their choice. But now it is not being imposed by Google. Clear? Yes. Globally. But what I can pass an order is in India. I mean, but this condition is there everywhere. Hello? Understood? Huh? So people with this try to understand what is the chapter. IOS, interpretation of statutes. So before we start, there are some definition systems. Let us try to understand this definition. What is that first one? Statute or an act. What do you mean by statute or an act? A law. Basically an act which is passed by parliament or state legislature. Next one, there is something called as document systems. What is the definition of document? Here and there, they can ask you one question. Macha, what do you mean by document? Document has 4 aspects in it, it seems. What are the 4 aspects in a document? One is called as matter. Second one is called as substance. Third one is called as means. Fourth one is called as record. So there are 4 things. What is that? One is called as matter. One is called as substance. Third one is called as means. Fourth one is called as record. Now, matter means what, people? It says what is the purpose of this document. Imagine, sir, there is an agreement. On the top of it, we have written it as it is an LLP deed. It says it is an agreement which governs the rights and liabilities between partners. It is a matter. So what is it communicating? What is the purpose? Purpose is always communicated in the matter. Sir, substance. What do you mean by substance? On what it is prescribed in the paper. Third one, means. How did it prescribe? How did we write it on this particular paper? How? Letters? Allala. Now, LLP did. How would we have written? We would have written it on using words. Letters. Now that is called as what? That is called as means. Meaning, how did we convey the matter that we want to convey? Was it through letters, numbers, or images? That is called as means. Record. Record means what? Device used for such interpretation. What do you mean by that? Sir, how did we write it? Did we type it? Did we write it with a pen? How did we write it? That is called as what, people? That is called as record. So a document will have these four aspects. One is called as matter. Matter says purpose. Next one is substance, on what it is written. Third one means how it is written. The fourth one is called as record. Using what did we write? Understood? So document means what, people? You can imagine. In our mind, it says a paper. Now, for example, Wasim goes on a top of a hill. He goes for a trekking. He sees one stone. What does generally people of the age of Wasim, what do they do as soon as they see the stone? They will remember their first crush. Now Wasim will write, Arrow, I love you, Jano. Just, oh, sorry, I wrote your second crush. I love you, Jasmine, from Wasim. Now, people behind Wasim, one more person was trekking it, Chirag. Now, Chirag wants to understand, sir, is this considered as document? Because you know, Chirag will get these doubts. Yes, people, is this considered as document? Is it a document? Huh? Is it a document? Now, let us try to put our definition here. Document should have four things. Correct? Huh? The first one is what? Matter. Sir, I think you're able to understand something out of it. It's a proposal. Second, what is the second one? Substance. On what it is written. There it was paper. Here it was stone. Stone is a substance. Third one. Sir, there it was words. Here it is. Arrow. People, it can be letters, it can be words, it can be numbers, symbol, anything. Now, heart here is a symbol. Sir, fourth one, how did he write? It can be chalk piece or it can be one of the most India's talented sculptor. You never know. Blood. Anna went to blood only. Now, people, that is only called as what? The fourth one. That is called record. How did we write? It can be a chisel. Sir, why is this important, sir? Stone can be considered as document. Stone. Stone. Macha, you all would have heard of Ayodhya case, correct? You all have heard of Ayodhya case. I'm just interpreting the law. I'm just presenting you the case. There has been a dispute of what is that? Who came first? Whether was it Masjid or it was the temple. Now, whatever went there was a matter of fight. It was a dispute. There is one set of lawyer who comes and says, see, based on this, we say that there was a temple first. Based on these, they say there was a masjid first. The matter went, it was not 10 years, it was not 50. IOS, 100 years. Tell me, the judge, the heart would have hit, what is that, beats per minute, 500 only. Because there are judges changed over a period of time. Because if I say them, gone. Communal disputes are there. I don't think it is sensitive. Now, if I have to say it belongs to someone, the judge's job is to clearly say on this grounds is what I'm telling you that they won the case, or based on this document is what I'm telling you they won the case. I have to be sure on that. Yes or no? What happened? Peace. Okay. Now, what happened? Based on one evidence is where the entire case went towards that it said that the temple was the first one in existence. and that evidence that was submitted in the court was a document, and that document was nothing but a stone on which there was the earliest inscription. You guys will go to so many places, right? Around your monuments, temples, or various places. They would have written something on that, right? That is a document and used as a valid evidence in the court. So it's not always document means a paper. This case proved it wrong. Agreed? That was evidence. Goosebumps, no? So people, that is what I'm saying. If you read document as document, it is a document. If you read a document as an actual thing, how it is presented in the court, you will understand how to interpret it. Wasim! Understood, Adam? Yes, sir. Wasim happy, be happy. Chanchal is like, sir, they took the stone only there. We can take picture and show, Nada. Chanchal is like, sir, did they bring that Jata, Bucha, happy? Full false. Okay, this part is clear. Huh? Hello. Hello. People, see this guy. CCTV recording of an incident can be considered as a document. Explain what do you understand by the word document and how will you justify your answer in accordance with the provision of General Clauses Act 1897. It is a general clause that it will come. But people see what they have given. A CCTV recording of an incident is a document. So, hey, I'm try to think. I'm going away from paper. We saw stone. Now we are coming to it can be a pen drive. It can be a tape. Now what they're telling you, it is considered as document. Even though it is not written on a paper, it is still a document because it records the matter, incident. It is stored on a medium, hard drive. There it is a stone. Here it is a hard drive. And it can be used as a proof in a legal proceeding. And hence it can be what is that? Considered as a valid document, and the General Clause Act will have a cross reference. It can be submitted as a valid evidence. I told you generally it will be a direct question. Such type of questions can also come. Hello. Clear all of you? Yes. Okay. The next definition they say, sir, is called what is the difference between deed and a instrument? What is the difference between deed and a instrument? Any idea what is the difference between deed and an instrument? Or you think they both are same? What do you think? Deed, instrument. Instrument can be anything. Now the answer script what you guys wrote is an instrument.
Like it's basically a deed is like a contract difference between parties. Well, instrument can be something that's showing ownership or any other thing. Like
Okay. Huh. Huh. Okay. In instrument, there will be some enforcement. Okay. Deed will not have enforcement. Okay. Someone else had something. Okay. People, In real life, we use deed and instrument interchangeably. One simple scenario, if I have to give what is the difference, if at all there is any instrument that is creating any document which is creating rights or liabilities, we call such instrument as people, which call such document as instrument. For example, you join articleship with a CA firm. Now you both enter into one document. You sign, that person signs. In that, it will be clearly written. Your pay will be this much. You have to work with me for 24 months. As an article, you're supposed to do this duties. As an article, you have right for remuneration of this much, expenses. You have reimbursement. You have all these rights. A document whichever creates rights or liabilities, transfer of rights or liabilities, we call it as an instrument. Your employment agreements, your internship agreements, your what else? What else? A marriage agreement. All this can be considered as an instrument. What do you mean by a deed? Deed is where there is a legal disposition happening. Now, when you are writing in the exam, you need to write this word. This is what is a major word that differentiates between deed and an instrument. Legal disposition means what? There's a transfer of something happening. Example, sir, I purchase a land. Again, you're writing everything. Correct. But there is a transfer of an asset involved. If at all there is any legal disposition happening, what do you mean by legal disposition? Nothing but change of hands with regards to any undertakings, or there is any liability being changed, there is any asset being changed. If such things happen, we call such things as what? Deed. Sir, if I have to give you an example, sale deed. What happens? I'm buying a land. The land gets transferred to my name. Share certificate. The shares are getting transferred to my name. Are you getting the difference? All of you, this word is gone. You cannot differentiate between instrument and deed. So if they're asking you, this is a major difference. So write down this point, this one thing. And one more thing that you need to write is this one. A legal document which may create rights or liabilities, not this one. This one. Which one? However, in India, there is no difference made between deed and instruments. Simply stated, you can say deeds, all deeds are instruments though, but all instruments may not be deeds. Correct? Huh? Because people sale deed, it is creating rights and liabilities. Correct? But not all instruments. In internship, what are we transferring? There is no asset being given to you. There is no liability being transferred to you. So keep that in mind and answer. All deeds has to be instruments. So instruments is a wider word. Deed is a narrower word. Clear? You had a question. Yes. Clear all of you? Hello? Okay. Possible question. Remember from exam point of view. Clear? Hello? Appointment order can be instrument. Yes, if you're appointing someone, that can be an instrument. For example, people, you guys have taken classes with us. Your invoice is an instrument. Are we transferring something to you? No, payment made, classes given, done. Getting the point? Hello? Of course, same deed only. Partnership deed. Capital. Capital is getting created, right? Now, whatever the money which belongs to me, I'm transferring it to the partnership through what? Through partnership deed. What about assets? Now, imagine I'm bringing in car as a capital. Can I bring?
Yes.
Possible, tangible, intangible, anything. Now, on what document I'm saying that I'm bringing in car as capital? I'm saying my car will be the company's car from today. Through which document? Deed? Correct. And we write all of that in partnership deed only. That Mr. A's contribution has been a car. There's a legal disposition happening. Yes? Clear? Hello? Okay. Next one, sir. Classification of. Okay, there is something called interpretation or construction. Okay, what do you mean by interpretation or construction? Da? Interpretation means what? Construction means what? Taka taka.
What do you understand about the interpretation and what you mean?
What do you mean by?
There's a definition in law and provision, and you're trying to understand that provision. I mean, you're interpreting it. But if you're making something, making something based on that provision, that's you're constructing something.
Okay. Now, for example, people, to understand that, now see here, I'll show you one scenario. I went to a park. Near the park, they have written this, people. No vehicles are allowed in the park. Comment on the statement explaining the concept of construction in legal interpretation. Mention its significance in determining the legal interpretation. So I go to a park. On that park, they have written, people, no vehicles are allowed. Yeah. Now, how do you interpret it? So I've been to a park. There, I see a parent, taking a, what do you call this? How can I forget? Huh? Trolley alla kanade, stroller. Edit madro. People, stroller it's called. You keep your kid in that.
Yes, sir.
Yes, sir. That's called a stroller. Now that was taken by one of the parent, which was not allowing me to walk freely. Now I'm seeing no vehicles are allowed. I'm saying this parent cannot. Exam question. This is what then my interpretation. Exam question. Yeah. So see, some questions are directly given by your institute. Some questions I've taken from various places. If not much, trust me, iOS, I'll be giving you only examples. If not, you can't understand. I just say interpretation means people reading 4 p.m. as 4 p.m. Construction means people you putting your effort thinking 4 a.m. alla 4 p.m. Understood? Adike, listen. Now, people, so I saw a stroller going, someone parent was taking. Now I'm feeling a park has clearly put Noda, you're not supposed to bring a stroller. And I saw one more kid doing a bicycle there. People, that also know people. I saw recently people. I saw. What is his name? Prithvi? Yes. Now, people, I was going in a park. I was going in a park. Listen. ಆಯ್ತು ಗ್ಲೋಬ್ ಥ್ರಾಟರು ಆಯ್ತು ಇವಾಗ ರಾಜ್ಮೋಳಿ ಎಲ್ಲ ಆಯ್ತು ಬನ್ನಿ ಇವಾಗ ಸ್ಪೈಡರ್ ಮ್ಯಾನ್ ಆಯ್ತಾ ಎಲ್ಲ ಡನ್ನ ಆಯ್ತಾ ಯು ಡಿಸ್ಕಸ್ ದ ಸ್ಟೋರಿ ಆಲ್ ಡನ್ನ ಆಯ್ತಾ ಹೇಳ್ಬಿಟ್ಟಿ ಎಲ್ಲ ಯು ಸೆಡ್ ಆಫ್ ಎವ್ರಿಥಿಂಗ್ ಹೂ ದಿಸ್ ಕ್ಯಾರೆಕ್ಟರ್ ಇಸ್ ಚಿರಾಗ್ ಇಸ್ ಕನ್ವಿನ್ಸ್ಡ್ ನಾವು ಲಿಸನ್ ದ ಪೀಪಲ್ ಐ ವಾಸ್ ಗೋಯಿಂಗ್ ಲಿಸನ್ Okay, now listen. Now this, someone was using this. Let us imagine a person was disabled. It was a remotely operated wheelchair. Yes, this is existing. So anyone walking, it is pushing them aside. Hands are coming in. Now people, you tell me, is this considered as vehicle? Now what happened? I saw a person who is actually using a wheelchair in the park, which is an automated one. Okay, now listen. Come back. Now I saw these people. I want to object it because simple people. I'm going and seeing no vehicles are allowed. Now tell me, people, what should I allow? What should I not allow? Interpretation is clear. I read it as no vehicles. That means only humans are supposed to walk. He is human, da. That chair came with him, man. So you have to treat this as a vehicle, no, da. See, I'm not saying you guys don't see what I'm trying to tell you is you're treating or you're trying to interpret it from his point of view. Is it required? Yes, the disabled people need and support, and yes, I totally agree. Yeah, we are not debating on that point. Now, how would the another person interpret the word vehicle? What should I allow? What should I not allow? Now that is the case. So now I'll take this. Sir, it does not create any mess, no pollution, nothing. So I can allow this. Now Swiggy or Zomato fellow, because it's a shortcut if you go through park, using his EV vehicle goes through that. Now can I consider this as a vehicle? I don't know why Wasim laughed at this picture so. Wait a he's imagining himself there. Wasim has fantasies. Okay, now see, exam question. Now read, listen here. Now people, no, first I'll complete it. Wait, wait, horse. You think that who else will be going? Wasim only will be going on the horse. Who else will go? Okay. Now, why we are trying to see? Now, see here, people. If I now there are two words I'm trying to understand. One is interpretation, one is construction. Reading the vehicle as anything which has two wheels, which is not technically like a walk, any other instrument you guys are using inside the park, I will say it's a vehicle, hence it is not allowed. That's one way of interpretation. That is only called as interpretation. I don't think, I don't mind what others want, nothing. I'm not using my brain there at all. Reading the word as a word. Vehicle means, according to me, anything which uses a wheel is a vehicle. And I will not allow anything. Now your brain works. Sir, construction. I understand. Now, if there is a person who is a specially abled person who cannot walk, now for him that particular wheel is mandatory. Now, because of that, I can accept it as an allowed two-wheel vehicle that is allowed. Sir, there is a stroller which a parent uses that cannot be considered as vehicle because it is not creating any harm. Now, if you are trying to understand it and you are trying to interpret it, that is the second word that is called as construction. Construction uses the circumstances to understand what this word means. I will not take the vehicle as just vehicle. I consider so many aspects to understand what vehicle means. What this person could have thought of on that day when he wrote, no vehicles are allowed. What would be his intention? That means probably someone going in a bike, someone going in a auto, or someone coming in a bus, whatever. Yet that is what is my intention. My intention is not to say even a person, a child coming in a stroller. My intention is not to prohibit them. Are you getting the point? And in apartments, why I'm telling it is important. It differs from place to place. There is a walking track in apartments. There, if you are driving your bicycles, it is considered as a mess by the residents because they have to walk. In one of the apartment, this is the issue. It became an issue. Whether can a bicycle be used because they saw the bylaws. It is not written. Can a bicycle be used on a walking track? Now you only see, think. It's a dispute. What you only think? See, a parent who has a child using the cycle will come and say, you have to allow the cycles to be used by the children. But a elder or a old aged, imagine a 65, 70-year-old person walking and the cycle is being driven. Now you know how sensibly you guys will drive. Yes, you don't mind if the person is not going out, you'll take them also with you. Yes, that's why I'm telling you, if you are considering, if you are going beyond the word, trying to understand the meaning, you call it as construction. Construction is not trying to understand what the word says, trying to understand what the circumstances say. If you're trying to understand the word as word, interpretation. If you're trying to go beyond the word, it's called construction. Here, hello, Pakka. I hope something is going inside. Talk, talk. Everything. No, I'll again ask you. Is everything going inside?
Yes,
Huh? Oh, it's already done now. Don't tell me. Because that will save my life literally. If that is the case, your law will be done today. Vandana. Trust me, Ramach, I'll tell you, you will not need me for second chapter. You will definitely need me for iOS. Pakka, I'll bet my life that not for everyone iOS is their strength. iOS is my strength. I'm making you understand the words which will be taught in 2x. Yes, I'm not simply saying this because my revenues are proving it. Yes, sir. That's why I'm saying it. So understand. So now see, there is second way of interpretation that is called as general classification of interpretation. Now, interpretation can be further classified into two isms. One is called as legal, one is called as doctrinal. One is called as legal. In legal, it can be further classified into two, authentic and usual. Now, what do you mean by that? Let us try to understand. There is legal. We further classify the legal interpretation into two. One is called as authentic, one is called as usual. Now, what do you mean by authentic way of interpretation? Simple, Damacha. At times, when we are reading a particular word, we will not understand how to interpret it, meaning how to understand it. The lawmaker says, hey, kaiku tension, why that tension? I am there now for you. I will only explain you what that word means. So give us an example. Associate company. Associate company means what? A company in which there is a significant influence. Now I am tensed. What do you mean by significant influence? Legislator said, don't worry, I am only telling you significant influence means at least 20% up to 50%. That's called as authentic. Authentic in our usual words means what? I generally say no. I'll ask you, much of where do I get authentic north to south to Spanish to Italian to nonsense? Where do I get this meal? You will say, sir, go here, sir. You get an authentic Andhra cuisine, authentic Tamil Nadu cuisine. So you're telling me where to go. Authentic means what? Sorry, everyone will do. No, for example, Chinese. Our Darshinis, Upaharas will also do. Put to black sauce, red sauce, white sauce. It should go and touch the roof and come back. That time, take the much. What? Correct? Huh? We are getting no Chinese. Gobi Manchuri. You get no. You get no. But you go and try to have it in actual Chinese. Correct? Huh? Where it is written as Indo-Chinese, you tell, come I'll show you. They are written as Chinese. I'll take it to Skanda and show. They're written as Chinese only. See da, Indo-Chinese simple. 2 capsicum, 1 onion, 1 red sauce, 1 black sauce. And keep hitting the hook. And the food has to touch the roof at least 5 times. The more times it touches, the more authentic. People, when I say Chinese authentic, authentic means what? The original form. Correct, huh? Original, exactly. When you are confused, the original interpretation is what is given by the legislator himself. Who is the legislator? The person who has written it. Not this person, the person who invented the gobi. Meaning Chinese. You need to have it there. Hello. Clear, huh? Sir, next one. Usual. Usual interpretation means what? Now let us take Wasim. I'll explain you what is Wasim. Wasim. Now people, what happened? Now Wasim, we wrote no Wasim with Jasmine. Now actually Jasmine saw it. Jasmine fell for Wasim because in front of the class, Wasim has proposed. How can she say no? In fact, she only gave a ring to Wasim. What did Wasim say? Now people think today is the day of wedding. No, Wasim, no question to you. Wasim, so how do you get married? This one? Tying knots, huh? They not. They, in your culture, how do you generally get married? Hey, wait, now my question. Hey, you don't do interview, wait, I am the anchor. You Madhyal Bandmata. It's my interview, wait, it's now the interview between me and Wasim. No, Wasim, I want to know how many knots do you tie? 3. Why not 2, da? Just try 2 and finish it off. Why not 2? Why not 2? Who said you will tie 3? Hey, if you tie 2 times, it's not a marriage, huh? Who said you to tie 3? Huh? I was reading it somewhere. Why? Huh? Now, people, remember. Remember, listen, Brahma, sir. Oh, I thought someone other sir without knowing me who came. Okay. Now see here. Listen, now people, don't you think from age immemorial, there are so many things you have been following like this without questioning where it is written, God knows, but all of us, irrespective of the religion, we all have that, right? Is it being written somewhere? No, it is being followed. Now, according to this custom, Wasim ties the 3rd knot. It is considered as a marriage. Yes or no? Now, people, Saptapadi, you do not? You do not? Sapta means how much? Why walk 5 steps? Why 7? Sir, விட்டுடுங்க sir. Sir, விட்டுடுங்க sir. Register marriage பண்ணிருக்கான். Sir, ஏன் விட்டுடுங்க sir. Now, people, exactly people is, there are words we do not know how to interpret. We just follow the way it has been interpreted with time. There are so many. Sir, will not believe, sir, all this is not so important. People, you guys know, during one phase, it became such a, there was one phase where there were so many amendments, so many things that were discussed, which was regarding one of the scenario that is called talak. You guys now know triple talak. Now my question, is it written in a law? Was it passed by a legislator? No. Now it is a custom. Like all of us, that is what I'm trying to tell. Triple talaq is a custom, was a custom. Now, any custom, according to our own laws, we all follow it because it's a custom. That's the meaning of usual. What is the usual way of interpretation? When it comes from some other source, not by a legislator. Lawmaker is not telling anything. Now, for example, if you ask me, now divorce is a matter according to our code. You need to go and file a case, mutual separation, 1 year, all that is there. But triple talaq was governed in a different way. Try to understand law as law. Don't take too much of deviations. Law as law. Now, divorce, you have to go to court, you have to file. But we value customary laws. For your example, I'm telling you, Hindu law, Mohammedan law, Christian law, Parsi law, all these are laws, but not acts. What is the difference? These are not made in parliaments. These are made by customs. Example. Now, when I'm reading Mohammedan law, when I'm reading Hindu law, when I'm reading Christian law, how do I understand which lawmaker has passed what? I have to take it as a custom. That is the meaning of customary. That's the usual way of interpretation. Understood? Now, people, I told you just now, section 6 or section 3A. I don't know how to interpret. Now, imagine in one of the high court, one judge says, Macha section 3A has to be interpreted like this. It becomes a law. Second one called as case law. You guys have read no? Salomon versus Salomon, Balforo, Carlick versus Carbolico, and whatever your childhood cases are. Hello. If something similar like that happens, you need to just follow the decision. Case law, one of the source. Hello. Okay. Next, sir. Next type of interpretation is called as doctrinal. Doctrinal can be further classified into two. One is called as grammatical. One is called as logical. Grammatical, nothing but people follow your English. Rules of speech is called as grammatical, meaning go word by word. For example, there is one legal dispute which was fought in a court on a labor matter. In one of the bylaws, they have not written a comma. Comma is not written. And because of comma not being written, the interpretation changed. And hence the company lost the case. The company had to pay around 76 crore as a penalty because comma was not written. It is not because comma was not written. The interpretation without comma was different. Rules of speech. I just go with English language. So if you are trying to read the law like that, it's called as grammatical. The last one is called as logical. What is logical is nothing but the vehicle. What does it say? When court goes beyond the words and tries to discover the intention. Vehicle means what? Understood all of you? Till now, whatever we've done, taka revise. What did we see? We saw the definition of document. What is the document? It has four things in it. First one, matter. It is nothing but what it is trying to convey. Second one, substance. Substance is nothing but on what it is being conveyed. Third one, means. Means is how it is being conveyed. Words, pictures, symbols, as the case may be. Fourth one, record. Record is nothing but using what device it is being conveyed. Okay, next we saw difference between instrument and deed. Instrument, transfer of rights or liabilities, or which has a, what is it? Transfer of rights and liabilities happen on any document. We call it as instrument. Deed, legal disposition happens. It's called as a deed. If possible, write an example in both the cases. Employment agreement can be an instrument. Partnership deed, LLP deed will be a deed. And remember, all deeds are instruments, but not all instruments are deeds. And next we saw Interpretation or construction. What is interpretation? Trying to understand the word as the word says, trying to understand the meaning in its word as the letters. You go with letter. What is construction? Construction is you go beyond the rule. That is the difference between letter of law and spirit of law. I say letter is the spirit means what? I wouldn't have communicated, but you should still follow it. Correct? Huh? Okay, next we saw interpretation can be classified into two things. What is that? One is called legal, next one is called doctrinal. Legal can be further classified into two. One is called authentic, which is given by legislator himself. Next one is usual, seen, custom or case law. Next one is doctrinal. What is doctrinal? Regular rules of speech. That is called grammatical. Next one is called as logical. Nothing but you try to understand the intention of the law. Clear? All of you? Pakka? Okay. Okay, go for a break and come. After that, we can continue with this. Okay, let's see here. The next topic, people, is called rules of interpretation or construction. Rules of interpretation or construction. Now, what do you mean by rules of interpretation? There are two types of rules. So, interpretation or construction can be further classified into primary rules and secondary rules. Now, under primary rules, there are again different rules. Let us first try to read what is primary rules. Online able to see here. Now, under primary rules, people, we have something called as the first rule, rule of literal construction. In Latin, we call this as people absoluta sententia expositor non indigent. Absoluta sententia expositor non indigent. Try to write what is the meaning there. An absolute sentence does not need an interpreter. An absolute sentence does not need an interpreter. What do you mean by absolute sententia expositor non-indigent? Expositor means a person who explains. Now, first rule, the primary rule of interpretation, people, simple. When the law is simple and clear, you're not supposed to deviate from it. Read the law as it is. Now, for example, if you take Vodafone, when they have clearly written in India, I will not interpret it. I will read it as in India only. I will not use my brain. Now, that only is called in Latin as people an absolute sententia expositor non-indigent. So what do you mean by absolute sententia? An absolute complete sentence. Expositor means a person who interprets the law, who explains the law. Non-indigent, not required. So when a law is complete, you do not require a interpreter. So in simple is nothing but people, when there is a word, read the word as it is. That's a simple thing. But at times people, even reading the word as it is, will not give you the meaning you need. You'll not be able to go forward. For example, there is one case, that case called people, it revolves around something called as beetle leaves. Have you guys heard of beetle leaves? That palm leaves, you have heard of it? One day what happened, people, in the place of Kerala, Bangalore and all these places, where the beetle leaves are there, one day what happened, they have okay, can you imagine like this? There was one seller who said, according to the law of the land, we need not have to pay tax on vegetables. So because of that, what did this person do? He's a seller of beetle leaves, the palm leaves. What did he do? He stopped paying tax to the government. So the sales tax officer saw 1 month, 2 months, that word started spreading. He started telling the other shopkeepers also, saying that you need not have to pay tax because on vegetables we need not have to pay tax. So they did not pay tax on selling of the betel leaves. One shop didn't pay, two shops didn't pay, the entire locality didn't pay. Now people, it started becoming a concern. Now what happened? A sales tax officer went and he issued a notice saying that on betel leaves you have to pay tax. He said, why should I pay tax on it? Your law is clear. On vegetable, we need not pay tax. The sales tax officer said, this is not a vegetable. But this person said, but you still eat it. The whatever started as a dispute went officially to the court. And in the court, now the question was whether betel leaves can be considered as a vegetable. When I say vegetable, green leaves, vegetable, whatever you call it as, can I consider it as a vegetable? That was a dispute. The matter went to court. Now you tell me. Judge is thinking, Dave, how do I interpret vegetable? Da? How do I interpret vegetable? How do I interpret? If you have written something as fruit, hey, you only think the you guys might be thinking, sir, can't they write as one schedule? And on that they can write no, sir, bendekai, tundai, that is finger and all everything, sir. You can write no list. People, you think that if you go back just 5 years, did we have this fruits like today? What you get actually imported cherry? Cherry was there, but we used to get sugar dipped. Did we add lychee? Did we have what is that? Dragon fruit, avocado. Did we have all this? Can I write all the fruits? Not possible. Now, how do I treat all of this as? Now, I cannot write down what and all are vegetables. Now, you tell me. First rule, absolute sententia, expositor, non-integer. Vegetables don't pay tax. Okay, vegetables. Now, how should I understand what is vegetable? Hello? Understood? Huh? So, people, what did they do? They tried to use the word, that is, they tried to use the help of dictionary, because dictionary will help us to understand what is vegetable and what is not vegetable. So what did they do? They searched something called as betel leaves. Yes, sir. Now we searched something called betel leaf. We thought it will help us. So this is what the definition it gave us. It's a red betel leaf is sometimes used as an antibacterial mouthwash. Betel leaves are also used to wrap betel quid for chewing, which also proves the beetle is a species of flowering plant in the pepper family. Piperaceae, native to Southeast Asia. It is hey. Now people judge was, hey, what are you trying to tell? Peperaceae, Southeast Asia and all. Huh? Now, I'm not kidding. This is an actual case. Now, what should I read it as? Now, people, reading a word as a word will not give me any meaning. I'm not able to give any judgment here. So, people, the rule of interpretation that was used in this case law was the literal rule, the first rule, that is nothing but I will use the word as the word only. But use the word not in a dictionary sense, use it in a popular sense. You go and ask every Indian, and I'm telling you, people, beetle leaves means vegetable. Will all of them believe you? No. How many of you think beetle leaves can be considered a vegetable? How many of you are convinced? How many of you are not convinced? Beetle leaves cannot be considered. This is only called as popular interpretation. Now, both of you have your interpretation. I'm not stopping it. But something your mind said, sir, this cannot be used in cooking. Now, I one second. People, when I say it cannot be used in cooking means you don't give me two items and say it is a vegetable. Does all of you use beans? All of you use carrot? All of you use beetle leaves for cooking? Popular meaning in popular sense. I understand. There are people in certain households you do use. I'm not saying no. A certain households you do use it. That's exactly what I want. Popular meaning to be understood in popular sense. If it was so clear, of course, there is no need of interpretation at all. That's why the case did not come on beans. It came on beetle leaves. Understood? Ah? Hello. Case law. Ram Avatar versus Assistant Sales Tax Officer. That's a beetle leaf case. State of Kerala. One more case was there. Can coconut be considered as vegetable or not?
Yes. Yes, sir.
Same scenario. Coconut. The tender coconut, normal coconut. We use it in. Yes, sir. Now people wait. How many of you actually use it in cooking? Okay. How many of you can cook the dish even without a coconut? I have not completed. Neha is like, sir, I'll kill you. Dare you comment about coconut? Now, people, remember, coconut was considered in the case as not as a vegetable, it's a taste enhancer. Exactly. You said Kerala. Why not other states? Correct. That's what they. I'm not coming and convincing you that vegetable coconut is a vegetable. I said what the judge said. You guys are like, sir, you go. We without coconut we can't cook at all. People, that's what I'm trying to tell you. This is a taste enhancer. Bandhavana. Understood? So what do you want to, how do we understand? The literal rule of interpretation means people. Okay, okay, concentrate. Back. Right on there. Ram Avatar versus assistant sales tax officer. Understood? They online no? Huh? Chicky na? Chicky. People, I'm not extending it. On ginger also there is a case. On lemon also there is a case. Yes? Ginger. Tell me vegetable. Taste and answer. Wait, 1 second. One minute. One second. You need not have to accept what I'm saying. Exactly is called iOS. What judge said. What judge said is holding good. You might now in break Wasim was telling, sir, I will tie 2 knots only. You said no, na? Yeah, and Mohit was asking, sir, why 3 only? Huh? No, exactly what my point is. I'm not saying this is how it is. It is different for you, it is different for me. That's why we are calling it as interpretation. And if we start fighting on it in the court, you cannot go forward. And the judge cannot keep blaming a lawmaker. Why did you make an imperfect law? He can't keep just blaming the lawmaker and sit in the court. The case will go on for 50, 80 years. That day, he felt this is how it has to be. That is how it has to be. Until some other court, I showed you the best example of Vodafone. High Court judge felt it one way. Supreme Court, then in judges only I'm telling you. So yes, you're right. If you're thinking, no, sir, coconut has to be made national vegetable, yes, I'll accept. Okay. Huh? Turmeric vegetable. Spice. Turmeric you eat. That one. That is different. Okay, clear? Okay, see what is the first rule? People quickly concentrate. It's a first and cardinal rule of construction. Meaning, plain words require no explanation. When language of statute is plain and unambiguous, no question of construction arises. Read it as it is. You're not supposed to deviate. When a word has 2 interpretations, one is narrower, one is wider. If narrower fails to achieve the object, follow the wider one. For example, if you guys walk into, say, temples or any historical places, museums, they would have written no photography. Can I do video? I'm asking you, why I tell you, someday someone can do it and say that it is written as photography. I will do videos here. But what I'm saying is a sensible thing. That is what is the meaning of when there is a wider one, when there is a narrower one. If narrower is not giving you a actual way out, then follow the wider one. Sir, example, sir, section 102 of Companies Act. What is 102? Explanatory statement. Disclose all your financial interest and such other interests. In such other interest, I will disclose mine, my relatives, not only what I make money. See, financial means I have to look at only money. What if someone said, you pass this resolution, I'll give you a job? No, that is not financial directly. It's a job for me. Should I disclose this? So, if at all a narrower one does not serve the purpose, then they're telling you follow the wider one. Next one, see here. Words are to be understood under natural and popular sense. Meaning what? I cannot read Peter Leaves dictionary meaning. Piperaceae, Asia, they say. What do we understand? Popular sense. You guys only said unanimously it is not a vegetable. That is a popular sense. Technical words to be understood in technical sense. You guys go and tell in your home. Please explain me person. What will they explain? What do you mean by a person? What will they explain? You'll say, hey, everyone in the world except you. Correct, no? All of you would have come across, you would have asked for a dog. They're saying you are there, no? Why that dog for us? Correct, no? Correct. Correct, no? So they say that, right? Now that is what they're telling you people. Popular words to be understood in popular sense. Technical words to be understood in technical sense. A person for a non-commerce student is different. A person for a commerce student is different. Because person for us is a technical word. IT. FEMA. ESA. Pakana. ESA. Now this is only called as the first rule. Absoluta sententia expositor non-indigent. Try to remember the example. These three are important. What? One is narrower, wider. Choose wider. One is if there is a word, if it is not giving you the meaning, then take the popular words in the popular sense. Last one, technical words in the technical sense. Clear? Any other example for technical? What do you mean by the word plant? Plant. Which comes out of the correct, no? And other part of you saying plant and machinery, no? Technical words to be understood in the technical sense. A botanical, biological, some person thinks plant means plant. We think it's a clear. People, next rule people is called Utras Majis Valiat Quam Paryat. Utras Magis Valiat Quam Paryat. Sir, now first thing that is coming to your minds, should we remember this? 100% yes, sir. I like your confidence. I know. Banda. Then why did they give you that? See, there are two ways to look at this. One, they can directly ask you, please interpret the maxim Utras Magis Valiyat Kvam Pariyat. Or second one, they might expect you to write what is the rule of reasonable construction. You can write the first point as the legal maxim. Yes, sir. How you interpret, Macha? From today, what you should do? Go home. Start telling this. Go home to your parents, to your friends, to your When they pick up the call, you have to say, Utras Magis Valyat Pam Paryat. They'll say, you converted man. What has happened to you? Yes, sir. Greet each other in this way. I'm not kidding. I'm not kidding. How did I learn this? Because people, you have iOS. I'm an LLB student. We had around 40, 45 legal maxims, and that is very important for us. Yeah. Then how did we used to do it? So every student used to have a code Latin sentence. So whenever I have to speak to this person, whenever I meet him in the day, first time, I have to tell this. You guys, can I do this? No. That we used to do it this way. So if I have to speak to Chetan, now I have to say, hey, Uttras Magis Valyat Pam Paryat. Chetan means that. Yeah. If why I'm saying that is, you guys will have around 7 to 8 legal maxims. Try to associate with your friends and try to remember. Yeah. Every day you have to start. Huh? Mutatis is not at all a rule. Mutatis is a rule. That is one word. That's all. Somewhere it comes. Okay, people. See here. What do you mean by rule of reasonable construction? Simple people. If general words fail, you will come and follow reasonable construction. See, this is read the word as it is. Here, we'll try to understand the circumstance. Understood?
Yes, sir.
That I'll tell you. Write down here one more point. Write one point here. It's a golden rule of, I'll tell you right now. Golden rule of, it's a golden rule of interpretation. Yes. What is the meaning? Maxim is this. Meaning is this. What is this? Statute must be interpreted as to lead a sensible meaning. What do you mean by that, people? Whenever the word is not serving our purpose, then we have to read the word in such a way that it will help us understand what is the scenario. I'll give you an examples. First, copy down. Then, so see, when the plain or grammatical meaning does not give a sensible meaning, literal construction, that is this maxim has to be followed. So first rule fails, you will follow this rule. Next one, if court finds meaning defeats the law, it is a duty of the court to depart from dictionary meaning and adopt construction which will suppress the mischief and advance the remedy. Mischief means what we are not trying to understand. Remedy means it will give us a solution. Now, for example, to understand this, try to see this particular example. What is that? We have already seen this also in your, what is that? In your audit chapter, disqualification of auditor. Rule 10.1 says what? A relative of an auditor may hold. Who what? A relative of an auditor may hold the securities in the company of face value not exceeding. Now tell me what do you mean by relative of an auditor? Relatives. Difference இருக்கா? இருக்கு. இருக்கா? Now can I say wife can hold 1 lakh? Brother can hold 1 lakh? Father can hold 1 lakh? Can I say that? Will the purpose be served? No. That is what they are telling you. When literal meaning, relative is what? One. If literal meaning does not serve my purpose, I have to go and construct it. Construct means what? I cannot go with the literal meaning. If I start taking every person can hold 1 lakh, that means what, people? The auditor will definitely become biased. We come from the land of relatives. Pakka, you and me are somewhere related. 100%. Yes or no? Yes. Now, they gave who gave? ICAI gave a interpretation. What do you mean by that? Seer. Rather than a literal interpretation, first rule, don't take relative as a relative. Reasonable construction is required and holding off shall be checked against the threshold. That is what 1 lakh is not for one person, 1 lakh is for all the group. This is only called as what? This is only called as reasonable construction. Relative. If I look at it as relative without trying to understand why I am telling this, why is there this imposition? Because the auditor may become biased. If I start giving one relative 1 lakh, then you're going to 20-30 lakh. You're done. Purpose will not be served. That's why we are going to interpret a reasonable construction. Understood? Hello, Pakka. That is construction. Reasonable construction. There also you guys would have seen for that only. Vehicle is considered as reasonable construction. Now vehicle, literal rule. Read the rule as it is. Construction, take the circumstance. Understood? And remember, you should never come and directly hop to the second rule. Literal interpretation is the first rule. If the plain meaning is not giving you the sense, a proper sense, then you will come and construct it. Casually, you will not come and construct it. Clear? Hello. Okay. Okay. Next one. Third rule, sir. Rule of harmonious construction. Let's go to that for the next one. Let us go to the next one. Easy one. Sixth one. Rule of edges dim generous. Rule of edges dim generous. Chirag's code word is edges dim generous. Whenever you see Chirag, you have to say edges dim generous. Now, what do you mean by edges dim generous means people? Now, people, you only tell me. Chirag anta. Okay, tell me people. What do you mean, etc.? So, can I put your lion? Tiger? Can I put rabbit? ಯಾವನೋ ಒಂದು ಆರ್ಸು ನೀನ್ ಯಾವ್ದೋ ನಿಂದ ಆರ್ಸು ಆ ಆರ್ಸ್ನ ಬೆಳಗಿಂದ ಆರ್ಸ್ ಅಂತ ಆಯ್ತು ಗುರು ಆರ್ಸ್ ಸಾಕ ಡಾಂಕ್ ಏನಾರ ಆಗ್ಬೇಕಲ್ಲ ಹಾ Now people, I did not write all of this. I just wrote etc. How did you guys think it is rabbit? Why not lion? But hey, 1 second, wait. Hey, edges dim generous. Wait. Now people listen. They listen. Now, did I tell you it is domestic animals? I wrote dog, comma, cat, comma, etc. Why did you guys think it is domestic animals? Sir, we are smart, sir. Dog இருக்கு, cat இருக்கு, அப்போ rabbit தான் இருக்கு. Pakkana. That's how your mindset. People, one more way to tell this. You're all from CA Foundation. Most your QA part and all you would have seen. 135. Yes, sir. No, people, I did not tell. You guys only filled. Your QA is again built on the same principle. That principle also is called as people edges dim generous. What in by edges dim generous? Edges dim generous means people, if there is any generic word, followed by specific word or special words, the generic word will take the color of the special word. Or if I have to say, or you can understand this way, if there are series of words which belong to one category, the generic word will also belong to the same category. That's how you guys said 1, 3, 5. The dash you guys said it will be a 7 or a 9 because it has set a path. If there is series of special words, towards the end, if there is a generic word, the generic word will take the color of the special word. You have to take it as a series. Understood? Hello. Perfect. If you guys have heard Ashbury versus Railway Carriage Company, there also the same thing would have come. Such other contracts. You guys have seen,
Yes, sir.
was there in your first foundation, like even in basics, you guys would have done, no?
Yes, sir.
Ashbury versus Railway Carriage Company. That is one of the example. Hello?
Yes, sir.
Yes? Okay. Not only that, sir. Okay.
This is like securities in terms of finance.
Hmm?
Let's say this like in security, if it's used otherwise, it's anything or protection or other means.
Series of words.
I'm not saying security
Security.
generally means something else, but when you take it, it refers to the act, it means something else.
That can come under your second rule. So for a security for other person is different, but for you it is shares or investments. Reasonable construction. Uttras Majis.
Somebody basically shares devices and other securities.
Yes. Perfect. Yes. I'll show you one real life example. Wait. People, what is Section 95 of Companies Act? Okay, this also will again come back. First, I'll show you one more. What is 19 Inspection. Who can inspect the registers? Members, etc. Members, etc. On. I read. They read. Wait, I'll tell you. Okay, we will read the third one. Any such member, debenture holder, security holder, beneficial owner, or any other person. Correct? One day, what was happening? One Belpuri and I was going outside the office. He said, "I want to come and inspect the registers." He came. He showed Section 94 of Companies Act. It clearly says that any other person, and hence I want to come and inspect the registers. First of all, the question here is, should the company allow this Belpuriana to come and inspect the registers? How many of you think no, not required? How many of you think yes, required? Why do you think no? Why no? No is not required. Why? Hey, wait, all of you. People, listen. Any other person. That is what my law said. Any other person. So it can be any person. I'm just giving you, see, to make your life easier, I said Belpuriana. I'll actually tell a journalist wants to come and inspect the register. Now your answers will change. Now tell me, a journalist wants to come and inspect the registers of a company's members. Now tell me how many of you think he can. You racist people, how unfair society you are. You guys did not live for Belpuriana. Just discrimination exists in the class only. What Arini? Tell them. Hey Arini, tell them. Tell. What? That is what is my point. I'm telling something. She's playing Ludo game there. Tell me. Should I allow the journalist?
Yes.
Chirag is like, yaar, sir, you know, some random person will come and inspect. Correct? No. People, see here, it's a real life case, people. Anil Kumar Podar versus Nesville Trading Private Limited. That's a real life case. Hello. Now, Amel Nodadana. Now tell me, should I allow? It was a real life case. Now, lawmaker has not written who is that person. Judge, NCLT bench has decided this case law. Again understood. Now, people, see here, any other person, listen, The rule that was applied in this case, especially was existing generous. Whenever there are some special words, such member, comma, debenture holder, comma, security holder, beneficial owner. Now that general word, any other cannot be, as you guys rightly said, dog, cat, lion cannot come. Correct? You guys said domestic. Here, the series, or if I have to call it as a species, the species here is they are telling any person connected with the company. Have they written the word creditor here? Can a creditor come and inspect? Answer is yes. Alva. Understood? Pakkana. This is called a rule of existing generous. Whenever there are special words and there is generic words like any other, etc., such other contracts. Now these do not have specific meaning. To understand the meaning of that word, you have to take the meaning of the previous words, the series. Now, sir, tell me, fill in the blanks. There is cat, there is lion, there is rabbit, there is eagle. Now tell me, what comes here? What comes here? You are not able to tell anything, no. In this case, existing generals will not apply. What do you mean by that? When the previous words does not form a specific series. Huh? You're still able to form a series? She's telling, sir, I got the series. One is domestic, one is commercial. Allah. Wild animal. So one is domestic, one is wild animal. One is domestic, one is wild animal. That's a series, correct? Understood? Hey, that's not how it is. All the birds should belong to the same series. Only then existing generous belonging to the same genes, species is what is the meaning. Hello? Pakkana. Now see here, what does it say? Existing generous, when will it apply? Whenever there is enumeration of. Enumeration means what? Not like Chirag said, lion, etc. There has to be two words at least. Enumeration constitutes a category. Lion, cat, dog, horse, chetan. This is not a category. Someone else done. Such class or category is not exhausted. Meaning I wrote everything down. I literally wrote what? Cat, dog, rabbit, horse, anything I can think of in that category. Everything I wrote. Now if I write etc., what else is left? Exactly. General terms follow enumeration. Towards the end is where general term comes. First comes special words. Next one, no different legislature intent is prescribed. What do you mean by that? Legislator has not defined what does any other person mean. If he has prescribed, follow that. Why? Who said it? Authentic rule. Legislator, when he says that, follow. Clear? Existing generous. Tell me, arms, ammunition, gunpowder, any other goods. What will come under any other goods? Wine? Huh? Grenade, correct? Yes, hello? Rat can come, correct? RDX, correct, no? No, we have to do two more. No pressure, but tomorrow we'll finish some and we'll be into normal. Okay, see it. Okay, see here, fast. There's one thing, let us finish and go. Okay, not 2-1. If you, huh? Okay, this is the last one. This one or two, your wish. Okay, then come. Rule of harmonious construction, easy one. Da. Hey, just because more points are there doesn't mean it's lengthy. Da. Again, you negotiate, mana. If I'm telling you after this is done, you can go home. 1 second, listen. Okay, rule of harmonious construction. What do you mean by harmony? Pizza. Oh, that one. Live harmonious. What is that? Together, unity. Correct? Hey, harmonious construction means what? Seed here. Wasim. In Wasim's life, only iOS is going on. Right from his college life to marriage, everything we are seeing. Okay, now people, rule of harmonious construction means what? Whenever there is a conflict between the provision of a statute, rule of harmonious construction shall be used. What do you mean by that? Now, for example, in one section, it says go left. In one section, go right. Where will you go? Tell straight. 40th batch to tell that. Yes, one section says go left, one section goes right. You need to make sure, try to read it together. Go left and then go right. See, why they are telling you is it is your duty to read the act as a whole. You cannot say that I'll just read one section, I'll leave one more section. You have to read the section, the entire act as a whole. You can't leave one and I cannot interpret one. But whenever, if I'm trying to interpret both, then I'm not able to derive a sensible meaning. Then they're telling you, do one thing. The special provision will always prevail over a general provision. To understand that, now, for example, if I have to give you, there is one article now, Article 13 of Constitution of India, just see what is the second rule says. The state shall not make any law which takes away or abridges the rights given by this act, and any law made in contravention of this clause shall to the extent of the contravention be void. In simple, in India, there can be no law made which takes away the right given by Article 13, and the Article 13 speaks about nothing but people, fundamental rights. No state, no, even the country cannot make a law which takes away the fundamental rights from you. Where is it written? Mother of all the laws, written in Constitution of India. There they are written. Now, if you look at it, there is one more section which says, what does this say? First one only see. Power of Parliament. Power of Parliament. Notwithstanding anything in this constitution, Parliament may, in exercise of its constituent power, meaning the power it has, major, amend by way of addition, variation, repeal means remove, any provision of constitution in accordance with the procedure laid down in this article. What does 368 say? If parliament wants, they can change anything given in the constitution. What does 13.2 say? No one in the law can ever make a rule which takes away a fundamental right. 368 is saying the legislator has the right to even remove that point also. What is 368 saying? Legislator is supreme. 13 is saying constitution is supreme. Now what to do? I do not want to do it, but I'm telling you, because of this conflict only, the most popular case, that if you know any LLB student, without this case, their law degree is incomplete. The case is called Keshavananda Bharati's case. Yeah, it's called Keshavananda Bharati's case. You had it? Okay, but yes, the conflict was between these two. It is the conflict between 368 and Article 13.2. I getting the point. Now, how do we have to interpret? After case one and the Bharati's case, the judgment was people, whenever there is a conflict. Now see, harmonious means what? I have to read entire constitution. In one place that will you, hey, it's okay da. You can amend even constitution also, forget any law. You can amend constitution only. But 13 says you can amend anything, but not fundamental rights. So sir, 368 is telling generally everything can be amended. 13 is specifically speaking about fundamental rights. Judgment given in case one and the Bharati's case, lawmakers, legislator has a right to amend anything. Yes, including the fundamental rights, but they cannot take away the basic form of the fundamental rights. You can impose conditions. For example, right to freedom is your fundamental right. But that doesn't mean you just get into a bus and you say, just take me and drop me somewhere. I'll not pay money. Imposing condition is on me. I can impose. Right to speak is your fundamental right. That doesn't mean you go and abuse anyone who you want. It's a fundamental right. Don't you think you can say? People remember, based upon right to speech, one industry took birth, and that industry is called journalism. Journalism took birth because of right to speak. That is right to speech. That's why they can speak anything, but that cannot affect any person. So journalism can speak if you have facts. Getting the point? So that is what was a judgment given in case one and the Bharati's case. You can do anything. Even you can amend the fundamental rights, but you cannot take away the basic form. You can impose conditions. That is allowed. But that doesn't mean you can take away the fundamental rights only. That's how they harmoniously interpreted Article 13.2 and 368. Getting some idea? Or everything is Pakka? Yes. Okay. One last example note today. Okay, see this one example. See the fast. As per the facts given in Raj Krishna versus Binod, there was a conflict between section 33.2 and 123.8 of the Representation of People Act 1951. Section 33.2 stated that a government servant may nominate or second a candidate seeking election, whereas Section 123.8 provided that a government servant is not entitled to assist the candidate in an election in any manner except by casting his vote. If you look at it, what they're telling you, in the same act, Section 33 is telling a government servant, a government employee can nominate one other person for elections. This power I have. Section 123 is telling a government employee with regards to election cannot do anything apart from voting. If at all that is true, then how can I nominate? There is a harmonious construction not possible. So in this, what they're telling here, Supreme Court observed that both these provisions should be harmoniously interpreted and held that a government servant was entitled to nominate or second a candidate seeking election to the state legislative assembly. This harmony could be achieved only if section 123(8) of the act is interpreted as conferring power on a government servant of voting as well as proposing and seconding a candidature. Meaning what? 123(8), you should read it as if the person has a right to vote and nominate. And you should not treat it as the person has only right to vote and nothing else. If I read it like this, then I will be able to go forward. That is what is called harmonious construction. Try to read both. Don't read one and leave another. That is what is this particular thing. Understood? Hello? Pakka? Hey, in rule of harmonious construction is right of one maxim. Generalia specialibus non-derogant. Generalia specialibus non-derogant. It means all Latin only. It means specific rule will override general rule. Specific rule will override general rule. Example is that article. Generalia specialibus non-derogant. General rule will not affect the special rule. Yeah, I hope you guys had cooperated. Okay, tomorrow we'll do. Attendance, sir, that's important. Tomorrow we'll start a little earlier, just to be on a safer side. 3:15 will do.
Yes.
We will finish early. We'll finish early. Just that we should not miss.